Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Hello and welcome to Your Inheritance. Today we've got a very interesting topic. It's called Resolving Disputes Between Business Partners or Second Generation Family Inherited Business Owners Without Courts or Arbitration, the Magic of a Confidential Mediation. And our guest is my friend, Richard Lutringer. I think I'm pronouncing the name right. I have to pronounce my name all the time, but I've got yours down.
I couldn't pronounce yours as well as you did mine.
Yeah, right. Dick Lutringer and I have been associated for quite some time. And Dick is an expert mediator. He has an extreme amount of experience in the mediation field, operating out of both Palm Springs, California, and New York City. Dick mediates family, business, probate, real estate, and commercial disputes in Southern California, New York, and New Jersey. Dick is nationally recognized as an expert on the mediation of family business disputes and has been quoted actually in the New York Times with respect to the use of mediation techniques to resolve disputes arising from all manner of things, but this one particularly was in family vacation homes. The New York Times ran an article on him on that topic. Dick is currently the chair of the Mediation Study Group of the Family Firm Institute, has a number of articles out there on that, a number of a whole host of organizations that he is a part of. In 2007, while practicing as a business lawyer in Manhattan for a very large national or international law firm, he began mediating, I guess, Dick, as a voluntary community mediator in Queens, New York, and just went on to go into extend his mediation practice into a variety of different organizations for the American Bar Association, for the New York City Bar Association, for the Association of Conflict Resolution, and other institutions. He is one of less than 50 U.S. mediators to have what's called an MC3 certification. We can talk about that in a minute and get that directly from Dick. Dick is also the organizer and chair of the pilot mediation program for the New York City Probate Courts. We're in California. I practice California law, but Dick is situated both here in California and in New York for his mediation practice. He's a certified mediator with a whole bunch of letters after his name. His law school credentials are quite stellar. Got a BA in philosophy in his undergraduate from College of William and Mary, specialization in international affairs from Cornell University, his Master of Comparative Law from the University of Chicago, and a certificate in family law business advising from the Family Firm Institute. He's a Ford Foundation grant recipient, studied European civil law at the University of Munich, and apparently is fluent in German. So I've learned all that about Dick. I knew it, but he's a very accomplished man and is going to talk to us about mediating complicated matters. And so first question, and first I have to say, the podcast people want me to say this and I need to say it. Nothing in this podcast is intended to be legal advice. If you need legal advice, contact your own attorney. Feel free to call Bochnewich Law Offices if you have a question. And we hope this podcast will be informative to you on this very interesting topic. And if you've got a family dispute over any of these things, especially family businesses, which can go on for years, mediating it can cut to the chase very quickly and get you a result that you might not get in court. So Dick, let's start off so our viewers can understand. What is the difference first between mediation and arbitration, and even between going to court and trial?
Well, thank you, Peter, and thank you for that very, very kind introduction. And you are one of the most respected state attorneys in this area, and I'm so proud to be on this program with you. So it's a real feather in my cap to be here. Arbitration versus mediation. Well, on the one side, procedurally, an arbitrator is like a judge who will make a decision, and that decision is yes or no. One side or the other wins. And of course, arbitration generally is not appealable. So you're stuck with that decision. If you went to court, a judge, you could appeal the decision. May not have the grounds to do it, but at least you have the right to do it. That's the one side. Mediation is a much more informal process where parties with claims, defenses against each other come together to try to resolve an issue without going to court, or they may already be in court, but beside the court. I like to say that arbitration and litigation deal with rights, mediation deals with interests. In other words, to resolve a mediation may not be exactly what a court would do or say, because the parties are not interested in that. They're interested in resolving the issue. So it's not bound by the same kind of limitations that a court or a judge or an arbitrator would be on. It goes as far as what remedies are. Remedies can be anything for mediation, whatever the parties are happy with. Courts are limited as to what they can do. So anyway, that's a long answer, but it's a different procedure completely from going to court.
And I think that viewers who are faced with litigation, most of my practice is trust and probate litigation. I'm in trial with some frequency. I just went out to trial in August, went out to trial in October. We managed to settle both of those cases during the course of trial. But getting ready for trial and all the rules you have to file to get ready for trial is a whole different. It's where I live, and when I'm in there, I love it. But we try to get to mediation before we go to trial as often as possible, because you can have a much more efficient conversation with the other side to reach a consensus, if a consensus is possible. So do you have any thoughts, I'm just throwing it out there, about when is an appropriate time during the course of a dispute to contemplate mediation? And do you think that, let's say, for example, you've got a complicated business partners, second generation family, inherited business owners, people are fighting over something like that. When is the right time? Or can you, I've seen it where people do it and they have different stages of mediation. They just don't try to do it all in one day. What can you tell our viewers about that?
It depends, but the general rule would be as early as possible, because you've spent the least amount of agonizing time on it. But sometimes it's not ripe. And that's why I think lawyers sometimes are important, because they can tell the clients what their rights are, and then they can decide to mediate it or not. But it may be too early. People may think things are unfair, but they may be unfair because life is unfair, not because the law is unfair. So I don't hesitate to tell people to consult a lawyer first. So with that caveat, I think early is good. As you said, you settled a case recently. The statistics are pretty clear. 90 to 95% of cases settle before a judge ever makes a decision. Now, if we all know that, why not move that settlement up months to do it early, rather than go through all of the gyrations of a litigation proceeding or an arbitration, if you can find the goodwill to do it. Often that's one of the problems. But often there is a questionable legal legal point which one has to resolve. But in general, it's not. People say, "Oh, how are 12 people going to decide it? Juries are going to decide it." That's almost never the case. It's always a settlement before that happens. So that's really what the alternative is: a settlement at the end or a settlement at the beginning. So mediation helps you reach that settlement
as early as possible.
Right.
As early as possible. You've actually sparked some thoughts in my mind. I mean, we often have discussions when we go to court, when the judge will ask us, is this ready for mediation? Whether the court judge is going to refer it to mediation, or the parties are contemplating a private mediation with someone with your credentials, which is often the case because people think, we want to get someone who's experienced in a particular niche area, and you pick a mediator who's got that experience in that area of dispute to resolve that particular case. But sometimes you got to get some discovery done. You might have to take some depositions, get some records. But there's nothing to keep people from expediting that process voluntarily either. If you're really trying to work toward resolving things, sometimes
excuse me, but no, that's true. In fact, in many mediations, we don't end up with a resolution. We end up in a schedule of when things are going to be distributed or given back and forth. What do you really need? Okay, can you have that by Thursday? That's the kind of thing that might take a month or two if you went through the normal litigation process. So,
right.
Yeah.
I want to seize on that for a little bit. So it's like in discovery, if you have a business dispute and you need to discover the books and records of the business for the topic we're on now, inherited business issue, we need to know what this is all about. If you're talking to someone in the language of litigation, you're talking about subpoenas, you're talking about requests for production, you're talking about interrogatories. There's going to be a 30-day time frame to respond. You could say, look, we want to mediate this thing. Let's get cut to the chase. Let's agree to produce these things. Let's expedite that, and maybe you can get to the goal of understanding what the subject matter is quicker, so you can get to that point of mediating quicker. Is that a fair statement, do you think?
Yeah, absolutely. And remember, in the cases that we're talking about now, there may be a business that is running. That business is hampered as long as this dispute is going on, either from a PR standpoint or from an internal operational standpoint. So it doesn't make sense to deal with the issue of an ongoing business the same way you might deal with a claim that's over and done with. You're just trying to collect it or get someone to pay money. In this case, the very future of the business may be determined by how you resolve this, and whether one person leaves or one stays, or one buys the other out, and so on. And I also should say that once people get involved in litigation involving partners or co-managers, the lawyers, because they have to put together a complaint or a counterclaim which meets the standards of mismanagement, for example, have got to dig through everything that happened and say, he did this, he stole this, he did. And then the people read it and they say, my God, he did worse. And so suddenly you've put fuel to the fire of this dispute. Whereas really what the end result may be that one leaves. and you would love, if it's a family, see, we have two systems going on here. If it's a family business, you have the family nurturing each other in their lives. That's one system. The other system is a business which has to compete with everyone else. There's a conflict very often between the two of them, and you don't want to destroy the family to save the business. So that's why it's important to be sensitive to the people's feelings and so on in a mediation, unlike litigation, because they'll even if the business is not together with the family forever, the family will be together forever. The cousins will be together. The aunts and uncles will be together, and you don't want that poisoning that whole future relationship.
So how do you prepare for mediation? And it sounds like what you do is sometimes you mediate a case that may last a day. Do you have cases where the mediation is we start a session, then we come back, and then we have to go in different successive sessions? And
yeah, very often that happens. Well, the first thing is I'll have a meeting. Sometimes it's just with the lawyers, which is just talking about the scheduling, when we can do it, who's coming, who is actually going to be at the mediation. And I am very open. Some people say, I only want the owner of the business there. I want the owner, his wife, and his sister if they're all involved, because it's much easier to resolve something if you get all the parties who have influence at the table than if you just have one person who has to then go back and report, well, no, I didn't get what I thought we'd get. Let them all experience that. So I try to, at that very beginning, go through that point with people and say, I'd like him to have his spouse there if it's a small business, and so that you can get input from there. There's a quote from Hegel, which is used in a recent book by Ken Cloak that I just love. And Hegel's a philosopher, 17th century philosopher, actually 18th century philosopher. And he said, conflicts, great conflicts, are not between right and wrong. They're between right and right. And that's really what we're dealing with. Both sides are right in their, and that's why mediation, part of the job is to try to show each side why the other side thinks they may be right. And that's really what we're doing. So anyway, the first meeting together, and then we'll have a mediation, and that might be because of Zoom. We're able to say, look, we're tired. It's now like 4 hours. Can anybody meet next Tuesday? And they'll look at their calendar and say, yeah, okay, so let's put this off till Tuesday. This is something which we really didn't have the opportunity for before Zoom that much, because people had to drive somewhere, park somewhere, then eat somewhere. Now they can do it at home. So then they come, and in the meantime, they can talk to the lawyer, talk to the parent, talk to their siblings, whatever, and come back refreshed. So then we have a second session. So that's very common the case. And it could go on 3 or 4 or 5 of them.
Especially when you've got something that's a complicated family business that is running. What you just said was very interesting to me, the quote from Hegel. I know a little bit about Hegel. I mean, obviously with your background, and you would probably have come across that and studied it with some depth. But that's true. It's important for people to understand that you're not there to go to clobber someone. You think you're right, they think they're right. Maybe you're both right. Let's see if we can see the other side's point of view so we can resolve this matter going forward. And what we're going to do in a mediated setting is cut out a lot of the necessary, to an extent, the necessary, I would say, term that people watching would be able to understand, the necessary bureaucracy or the functions of the language of litigation that slows things down almost to a glacial pace in some people's minds. What I think is a quick case going through the court would not be perceived that way by most people. But if you go to mediation, you can cut to the chase. You're not having to wait around for anything, and the mediator can control things, and the mediator can be the metronome to keep people, in line. So that brings up my next question, and your philosophical reference is important. What kind of an attitude should a person come to with mediation? What do you think? What would you, when you're talking to the parties who are mediating, what do you try to give them the sense of how they should approach it?
Well, I think they should see it as an opportunity. It's not a something you check the box of before you go to litigation. It's an opportunity to move into a different sphere. And they should keep an open mind. And they should be prepared to change their mind. I mean, that's hard to tell people because they come into litigation really with a very strict mindset about what's going to happen. But neuroscience shows that it takes people time when they hear something, a changed fact, for example, that they thought something was true and it's not true, and find out. It takes some time to get from one part of the brain to the reasoning part of the brain. They still don't quite believe it. So you can't push some things. I mean, there has to be a certain process of slow education. And so I think that when I talk about what bring to the mindset, it's a mindset of being open to convincing the other side that you're right. And for lawyers, one of the beauties of mediation, and I think this isn't said enough, is that this is maybe the only time you will have the other side's client in your space. And you can tell him in layman's side why you think your case is strong and so on. He's only heard it from his lawyer, who's full of, they don't know what they're doing, all the kind of stuff lawyers might say. But this, if he's a very charismatic guy, can appeal directly to the client on the other side. That's a benefit which you don't often get. So that's one of the things you can do, and why I think lawyers too should see that as their main opportunity, not to lord it over to the other side, what a great case they have, but to sympathize with the other side and say, I see how you might say that. But in other words, really make them feel inside like they're heard and that they're appreciated, even if they're on the other side of the case.
Yeah, you're not there to grandstand your case. You're there. I mean, obviously, the lawyers have to meet their duties of zealous advocacy for their clients and the Business Professions Code and all those sorts of things. I think that the benefit, though, and I'd like to ask you about this a little bit, a mediator is not a judge. A mediator does not make a decision that binds the case. It's a voluntary process. People have to agree, and the mediator is the person who tries to broker that agreement. But what a mediator like you, seasoned, you've got the gravitas of all the experience you've had. You've practiced law for many, many decades in a nationally known law firm, all of those sorts of things. It's the first time that someone is going to be getting an opinion other than their lawyer themselves about their case that is neutral, right? And or not an opinion, but it's like, well, you got to look at it from this standpoint, or you got to look at it from that standpoint. Do you have like a theory X or theory Y approach, or you do it on a different people, or do you poke holes in one side's theory if they ask you to? How do you approach it?
There's a concept called an evaluative mediator. And an evaluative mediator is like an ex-judge who you come to him, he's seen 100 cases like this. He'll say, no, this is the way it goes. I've seen that before. And basically tells people how he thinks it's going to come out.
How he thinks it's going to come out, how he thinks the judge will decide.
How strong their case is and so on, and often dumps on them or whatever. He really tries to be a judge. I am what's called, or what I call myself, a devaluative mediator. I go in and it was sort of Columbo-like. I say, I don't quite understand how you're going to make this work, and not build people up in caucus as to how strong their case is, but say, these are the problems I see. How are you going to prove that? And in other words, put holes in the case. They may not be so deep that they can't overcome them, but make them feel like I understand their case, and I'm not trying to hurt them, but I'm trying to give them a reality test. This doesn't really quite make sense. And I try not to ever make any conclusion as to win or loss on either side, because first of all, I don't know. Secondly, if I take a position that's a conclusory position, it automatically puts me in on the other side to that lawyer, and he then sees me as counter to him. I want to see him. I want him to see me as his best friend. His best friend will tell him the truth, but not that I'm trying to win the other side's case for them. So, yeah, I am as I said, a devaluative. I try not to promote a case unreasonably, saying, "Oh, you have a better case than them." I never would say that. That's not.
You
my
don't
job.
see you're not there to validate one side's view of their case or another side's view. You're there to understand it, discuss that with them, but move people toward the middle. And in that process, I have my next question is: do you have any statistics or estimates as to what percentage of cases resolve that go to mediation? In other words, people, my sense is that if people make the choice to go mediate, there's a very high percentage that I can't even think of a case that went to mediation that in recent past it didn't. So I can think of a few cases that went to mediation where people are still arguing over the terms and the order that's got to go to before the court to approve the settlement agreement and so on and so forth. That's my world. But what can you tell the viewers look, if you choose to go to mediation and it's the right time and it's ripe, as you say, and I'd like to ask you about when do you think something's ripe, but what estimates do you have as the percentage of cases resolve, or maybe what's your batting average on that a little bit?
Well, if there's a private mediation, they come to resolve a matter with a agreement with me. It's close to 100%,
Yeah.
because they've already crossed that barrier to say we're going to settle this case. It's just how much, and so on. So that we can deal with. If they have to do it, many courts say, as you know, you have got to mediate this, or it's in the court rules, have to go to mediation. Some of the lawyers see that as a check the box thing. I've got to just do it because I don't want to tell the judge we didn't do it, but I'm not really interested in using the mediation to settle the case. In those cases, I mean, it's their strategy in their case, so they can do what they want, but I'd say those are like 50%, So 100%, 50%. I mean, in some areas of the law, it could be as high as 85%. But and if I don't have lawyers there, I'm not dumping on lawyers. It's a higher percentage because it seems to me in smaller cases without lawyers, people are more willing to. They're more afraid of what's called their batna. What happens if it doesn't settle? They go to court, and then they've got to deal with all those unknown things. So it's sometimes easier without lawyers. But anyway, I'd say 50% if it's court ordered, 100%, probably 95% if they agree, and yeah, that's probably
Right. I mean, some people might. You get a court-ordered mediation. I mean, in my world of trust and estate litigation, the court can order parties to mediation. There's a case on that in California, Breslin v. Breslin. There's the Breslin decision. There's other policies of the local courts. They could order you to go to try to settle, but they can't make you settle. But my philosophy has always been, if the court's suggesting it and their court is going to be your trier of fact, it's a good idea to go. But we don't go to just have a perfunctory check the box kind of thing. You want to have a meaningful attempt at resolving the case, because it's in the best interest of the client to get the lawyers off the clock. And if they can resolve it and they can stand it, they can take it, right? It's better for you're meeting your duty to your client by getting them that result. That's certain, right? You're getting a certain result. Do you explain that to people when they come before you?
Absolutely. They're always free not to settle, but if they do, then they're in a little bit of a crapshoot. I mean, law is more serious than a crap game, but very often the result is I can't count the number of times people have said to me, the judge didn't understand the case. He didn't get it. He must not have studied my brief. You know, they're trying to justify, well, you don't have to do that if you mediate and settle. You don't have to worry about those things because you've taken care of that. You've paid a price for it. You pay because you're not getting 100%, but you've also given a lot of peace of mind that it's settled, it's over.
And mediation, the mechanics of it. Do you typically have all the people in a room in a joint session, or do you break it up, or how do you approach the mechanics? Let's say you've got people really adverse to each other. And it's a Zoom mediation. You're doing it remote. How do you approach that? Or if you could give examples of that.
Yeah, well, my default is to try to have them together at least for a little while. And to tell you, one of the main reasons is that I'd like to see them see everybody, so they see who's there. I'd like to see them agree on very basic elements of the case. What day was the contract? What was it? In other words, all the things that are because there are some things which they don't agree on. I don't know they don't agree on it. And then they're in separate rooms and it's much harder to resolve it because they don't know that. So I go through some basic things. Some of the things are pro forma, some of the things are more serious. And then I see where the dispute is. And then we know, everybody knows what the dispute is about by having them together. It doesn't help much I do have the parties state their position, but I don't spend a lot of time with that. It's not really a point to argue cases and so on. But again, as I mentioned earlier, each lawyer should see that as a wonderful opportunity to explain to the client on the other side why they're not excuse my French, but that's what the lawyer's been telling you. And so
it's a podcast. I didn't see that coming, but it's okay. It's okay. Yeah, you're putting people in a room. You're saying, people get into their tribal positions on cases, but there's some things when they go before a mediator who can listen, empathize, hear it out, explain, and maybe ask questions that would provoke them to think about another person's point of view, which gets to consensus, and consensus is a way to get a result certain and save a lot of money on attorney's fees.
I couldn't have said all that better myself. That's exactly right.
There you go.
Exactly right. And the first thing you said is more important than all the rest, and that's the word listen. Because it's not so much, although it is to get what they're going to say, it's to make them feel heard. And if they feel heard, then they'll open up to listen to the other side. So you have to go through that step, have to really seriously listen, and then they're not thinking all the time, what am I going to say? They get it out. Everybody's heard it. Sometimes there's a lot of venom. And in those cases, I try to put them in a private or breakout room, if I know it's going to happen, and let them give me the venom. In other words, I can say, oh, that's terrible. I heard that. Oh, yeah. And so they kind of get it out. They've told an authority figure what they're upset about. And then we can go back and continue.
Yeah. Further on the mechanics of mediation, people relate things to you. You become their sounding board. They listen to you. They can vent to you. And then, but none of that's admissible before a court subsequently if things don't
Right.
work out. And your policy that you state, you can only relate to the other side what the other side gives you permission to relate.
Exactly.
Right.
Exactly.
How do you explain that to people?
Well, I say pretty much that. I say there's double levels of confidentiality. Well, everything that's said here today will never get back to the court, no matter. So it's a space you can feel free to talk in. And if you tell me something privately, I'm not going to tell the other side that unless you give me permission. And I might ask you for permission because I would think sometimes you're better off showing your strength than holding it back, thinking I'll destroy them with this. They never asked for it in discovery. I'll get them. You know, the end never comes sometimes. You know, you may end up never telling that, and yet it's valuable for negotiating purposes.
All right. Do you have any examples of any interesting? I mean, I know I can't get into the specifics, naming parties and things like that, but do you have any examples of cases where it was long, it was complicated, it took multiple sessions, it looked like people were really adverse to each other, but at the end of the day, they did work it out, and you got an agreement, and the business was allowed to go forward, and you know how that process unfolded for you?
Well, I can give you a couple of examples. It's not always so rosy at the end, but at least it's over. I had one estate where there were 3 daughters. Each one got 30% of the properties. There were commercial properties in New York State, and each one was worth about $30 million. I mean, each one got $30 million worth of properties, unencumbered, okay? And some of them were businesses. They were very valuable. And then there was one daughter, she didn't get her 30, she got 40. And that 10% difference, which actually was only 3% or only a third difference because they each would have shared that 10%, caused the litigation to last 8 years. And before I was brought in. And they had been fighting over whether the mother had wanted to give it to her, whether she was sane at the time, all the things you know very well. And the lawyers had made millions on it because it was just never ending. And so I got in there pretty late. It was actually not early enough to keep the relationships from being destroyed. Sisters didn't talk to each other. Their daughters and sons didn't have holidays with each other anymore. It was horrible. And the mother apparently had said, I want this one daughter to decide how best to resolve that and give that away. Now, that was, well, I'm not arguing whether it was a good decision or not, but she should have communicated that early. That's what she was doing. And everybody would have understood it. And may not have liked it, but it wouldn't have been the subject of a controversy. Eventually, they did split it up pretty much that way, 30-30, 1/3 each, which could have been done on day one and gotten over with. But that was a case where the procedure, basically, of the probate court just kind of let the thing move on and on and on and on. And
they do go on sometimes. You have cases like that go on for those multiple years. You touched on some philosophical ideas and precepts. It's almost not in a position to judge anyone, of course, but it's almost these family disputes over those kinds of things where clearly there's enough for everybody. Right? There's plenty here. No one's missing any meals in a windup of an estate of that nature, according to those percentages, or having any hardships when you're dividing up a estate with the kind of cases in business litigation cases that you sometimes, or apparently with some frequency, get involved with upwards of values of close to $100 million, and they go on for a long time. And certainly those are complex, but it's almost like there's biblical precepts against that. You know, I mean, it's like, you're not supposed to do that. I mean, Old Testament, New Testament, any philosophy you can think about is like, what are we doing here about that? You're talking about that little fraction of a number. you've got to be able to do that because everybody's benefit. I mean, and to expend probably more than the percentage difference on
definitely
fighting about it is, and the anxiety that you breed and the division in your family, it's a good idea to try to resolve that, like you say, as early as possible.
One of the big barriers is what I call OPM, and that's other people's money. And that if they were paying that out of their pocket each month, rather than some estate pool somewhere, they might not push the litigation that long. So I see this happening in all kinds of litigation. If someone else has funding it, they can have all kinds of principles they want because it's not affecting them. So that's a barrier sometimes. Anyway, there have a number of business cases where we have been able to negotiate. One was 3 Italians owned a restaurant in New York City. One was the cook, one was the man in the dining room, the maitre d', and one ran the bar. And it turned out after they did some careful looking that the guy in the bar was taking a lot more out of the cash register than the other 2. I mean, it wasn't just cash, it was ways he was doing it. So rather than destroy the business, we negotiated a way of him exiting slowly out. But it could have been very, very ugly. And they were related too. So fortunately, he got out with his life.
Well, we don't want to go into any of that,
No.
Anyway, what kind of situation we're dealing with there.
Issue.
But what you're talking about is, someone did something wrong. They got, but it's a way to you have a dispute, but you can fix the family dispute, and as much as possible, handle the financial issues, handle the legal issues in an expedited fashion by way of an agreement that everybody knows what they're getting. They're signing on to it. They're not waiting for someone to deliver a decision that they might not like, and where it might be a win, lose, or draw, or it's something that nobody likes. You're negotiating a resolution through someone with your abilities, and you also, at least to some extent, might be able to preserve family relationships to the extent possible.
That's the hope. That's the hope, and certainly all of the peripheral characters around them, wives, mothers, children, that's what they want, And so it's really that's why it's a joint decision, or it should be, to get rid of this thing.
Well, Richard, we've been going on for a while here. I appreciate your coming by. I hope you come back again. We'll have to do coffee again soon, like we just did recently, and talk about e-bikes and motorcycles and all that other stuff. But thanks for being on the show, and we'll make sure that people have your information, and if they need a mediator, that they can contact you through our links that we will post to the show and to the website and so forth. And thanks for being here, and really appreciate it.
Peter, it's been a delight for me, and you're so perceptive, and really your questions and your comments were so good that I appreciate this talk a lot. Thank you.
Thank you.
You've been tuning in to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. If you're being sued over an estate, or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.